Now, beyond Edward Snowden's dilemma, the NSA is still experiencing both domestic and international fallout from the leaks detailing its surveillance program. The Electronic Privacy Information Center, EPIC, as it's better known, filed an emergency petition directly to the Supreme Court to end this surveillance. It says, quote, the NSA's collection of solely domestic communications, which has been acknowledged by the President, the Director of National Intelligence, and the chair and ranking members of the Senate Select Committee on Intelligence, also constitutes a legislative rule that substantially affects the public to a degree sufficient to implicate the policy interest animating notice and comment rulemaking under the Administrative Procedure Act. Accordingly, the NSA's collection of domestic communications, absent the opportunity for public comment, is unlawful. So it's breaking the law. And that isn't the only lawsuit the government has coming its way as a result of the revelations of the NSA surveillance program. Here to tell me more about EPIC's petition, the man who submitted it, Alan Butler. He's EPIC's Appellate Advocacy Counsel. Thank you so much for joining me. So first of all, let's talk about this emergency petition. Why did you decide to file it directly to the Supreme Court instead of going through the process of lower courts first?
Sure. Well, our petition is asking the Supreme Court to review the decision of the Foreign Intelligence Surveillance Court, specifically the decision regarding Verizon telephone communications records. So we're asking the Supreme Court to review the decision of the Intelligence Court because, as a Verizon customer, those records affect us. In addition to millions of Americans, and because of the unique format of the U.S. surveillance law, there's no other place we can go. We have to go directly to the Supreme Court to challenge what we allege is unlawful surveillance.
And let's talk about the main argument of your petition.
Sure. Well, our petition, and again, to clarify, we have a mandamus petition with the Supreme Court, and that petition alleges that under the foreign intelligence law, that it is unlawful for the Foreign Intelligence Court to issue an order like it did to Verizon that requires the disclosure of all call detail records related to calls that that company processes.
And as I understand it, the reason that that is important is because you have to have, in order to have one of these surveillance programs, a very specific kind of argument against the person that you want to tap. Is that correct?
Right. So the legal standard here is relevance. And what's required under the foreign intelligence law is that the records collected, in this case business records, are relevant to an authorized investigation. And it's our contention that it's since implausible that all telephone records of Verizon customers are relevant to a particular investigation.
So realistically, what do you think the chances of your petition being heard are?
Well, we believe that the court will take our petition seriously. There's a critical issue of law that the court hasn't considered in the past and that it has the direct opportunity to consider now. We're asking for extraordinary relief, and so that always comes, with limited prospects, but at the same time, we believe it's a critical issue and it really is an extraordinary circumstance.
However, at the same time, given historical precedent with lawsuits of this type or petitions of this type, things really haven't changed. Now, a 2005 New York Times investigation was the thing that first brought up the warrantless wiretapping program. There was a lot of lawsuits filed against individual companies as a result of this, and that allowed these, and they were trying to say that that was their fault that they allowed the government to have this kind of tapping program. Now, when that law changed in 2008, Congress retroactively relieved the companies from this type of liability of being sued. Do you think that something like that, some type of retroactive action, can play into your petition or future lawsuits that we might see?
Well, I think our petition really gets to the heart of what Congress changed after those revelations that you mentioned. The NSA was, during the Bush administration, sweeping up communications records somewhat similar to what they're doing in the lawsuit and sort of the facts behind what we're challenging here. And when the Patriot Act was passed, reauthorized in 2005, they amended the provision, the exact provision that we're dealing with here, and the provision again requires that the records be relevant. And we're basically making clear that the bulk collection of telephone communications records is not the same as collecting records that are relevant to a particular investigation.
However, one other point of contention to bring up is that the reason a lot of those lawsuits back in the past failed was because they have to have this burden of proof. They have to prove that, yes, they were specifically tapped. And a lot of them can't prove that because the fact is that these programs are secret. The surveillance is secret. So do Edward Snowden's documents or do any other documents prove specifically this burden of proof beyond reasonable doubt?
Right, so standing has been a problem in the past. This year we saw in the Clapper case in the Supreme Court that 5 out of the 9 justices decided that those plaintiffs did not have standing, and thus the court didn't review the legal claims. But in our case, we have an order from the Foreign Intelligence Surveillance Court specifically citing that Verizon Communications records are obtained and we're a Verizon customer. So we believe we can get over that hurdle.
Very interesting. Please keep us up to date with your petition and what comes of it. Alan Butler is the Appellate Advocacy Counsel at EPIC.